Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you.
My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law.
The primary problem with Amendment 14 is that it cannot be changed short of a constitutional amendment. This is a significant hurdle to fixing things that may need to be fixed. Now let's take a look at the mandatory in-state ownership requirement first. Okay. All medical marijuana cultivation facility, medical marijuana dispensary facility, and medical marijuana infused products manufacturing facility licenses, entities with medical marijuana testing facility certifications, and entities with transportation certifications shall be held by entities that are majority owned by natural persons who have been citizens of the state of Missouri for at least 1 year prior to the application for such license or certification. Notwithstanding the foregoing, entities outside the state of Missouri may own a minority stake in such entities. Look, this clause is clearly unconstitutional. The Dormant Commerce Clause ultimately means that because Congress has been given power over interstate commerce, states cannot discriminate against interstate commerce, nor can they unduly burden interstate commerce, even in the absence of federal legislation regulating that activity. Any state law which affects interstate commerce must not discriminate against out-of-state actors or out-of-state competition, or having the effect of favoring in-state economic actors. If the law is discriminatory, then the state must show that it has no other reasonable means of advancing legitimate, local, important, non-economic state interest, such as health or safety, purpose. Now, the law must not be unduly burdensome. If the law only incidentally burdens interstate commerce, or if the law is non-discriminatory, the court will balance whether the benefits of the state's interests are outweighed by the burden on state commerce by looking to the following. Are there less restrictive alternatives? Are there any conflicts with other states' regulations? You know, this case is very similar to the Tennessee Wine and Spirits Retailers Association v. Thomas, decided in June 2019 by the Supreme Court. Here are the facts of that case. To sell liquor in the state of Tennessee, one must have a license from the Tennessee Alcoholic Beverage Commission. Under the Tennessee Code annotated 57-3-204B2A, an individual must have been a bona fide resident of Tennessee during the 2-year period immediately preceding the date upon which application is made to the Commission, and there is a 10-year residency requirement to renew a liquor license. The state imposes similar requirements on these other entities seeking a license. 2 entities did not satisfy the residency requirement when they applied for a license with the TABC, so the TABC deferred voting on their applications. The Tennessee Wine and Spirits Retailers Association, which represents Tennessee business owners and represented the 2 entities here, informed TABC that litigation was likely. In response, the state attorney general filed an action in state court seeking declaratory judgment as to the constitutionality of durational residency requirements. The association removed the action to federal district court. The district court determined that durational residency requirements are facially discriminatory in violation of the Dormant Commerce Clause of the U.S. Constitution, and then the Sixth Circuit affirmed that. Now the question in that case was, does the Dormant Commerce Clause permit a state to regulate liquor sales by granting licenses only to individuals or entities that have met state residency requirements? The Dormant Commerce Clause forbids, notwithstanding the 21st Amendment, a state from regulating liquor sales by granting licenses only to individuals or entities that have met state residency requirements. Now, Justice Samuel Alito delivered the 7-2 opinion of the Supreme Court. The court's Commerce Clause jurisprudence holds that state law that discriminates against out-of-state goods or non-resident economic actors can only be sustained on a showing that is narrowly tailored to advance a legitimate local purpose. Tennessee's residency requirement favors residents over non-residents. The court concluded that protectionism is not a legitimate local purpose, and that residency requirement, quote, has at best a highly attenuated relationship to public health or safety, end quote. Now, Justices Gorsuch and Thomas dissented from that opinion, arguing that the 21st Amendment of the Constitution gave states broad authority to regulate alcohol, which encompassed the ability to impose residency requirements. There is almost no chance a federal court would tolerate a similar residency restrictions if applied to any other legal business. But since cannabis remains an illegal Schedule I controlled substance, courts may be reluctant to even entertain a dormant Commerce Clause challenge to state cannabis laws. Even so, it's only a matter of time before the federal government recognizes cannabis as lawful commercial activity. And once that happens, these residency restrictions could be immediately susceptible to constitutional challenges that will most likely succeed. In the meantime, federal cannabis prohibition provides states a legal cover to experiment with regulatory policies that will not pass constitutional muster. To avoid these time bombs, the states should and probably will relax or remove residency requirements ahead of national legalization. If not, the states are going to expect that out-of-state investors will force that change through the courts. In Missouri, they're going to have to because it's in our Constitution. And if it was not for the fixed nature of our Constitution, this wouldn't be an easy legislative fix. However, because it is in our state Constitution, that fix is very much harder. A litigant may well be able to stop the entire licensing process across Missouri by filing suit and seeking to enjoin the department from awarding any licenses without fairly considering companies with out-of-state majority owners. This also impacts the taxes. The Amendment 14 requires that the Missouri Veterans and Healthcare Fund be created and funded by taxes and fees created through the medical marijuana amendment. The funds, less some operating expenses, shall be transferred to the Missouri Veterans Commission for health and care services for Missouri veterans, including the following laundry list of purposes: operations, maintenance, capital improvement of the Missouri Veterans Homes, Service Officers Program, and other services for veterans approved by the Commission, including, but not limited to, healthcare services, mental health services, drug rehabilitation, housing assistance, job training, tuition assistance, housing assistance to prevent homelessness. All the monies from taxes authorized under this subsection in the amendment shall provide additional dedicated funding for purposes enumerated above and shall not replace existing dedicated funding. Now, Missouri State Representative Chuck Basie on December 2nd, 2019, pre-filed a bill to authorize submission of a constitutional amendment to the citizens to repeal and replace Section 1 of Amendment 14. What Representative Basie would like to do is make direction of funds dedicated by the amendment. Although, when the legislature had the opportunity to pass medical marijuana through the legislature, they punted. They refused to take action. Make no mistake about this, while the proposed change to fund the Veterans Clinic in MU, a worthy goal and something the legislature should seriously consider doing regardless, the ultimate goal here is to start making cracks in the funding mechanism so that the state legislature can get its grubby little paws on this pool of money. The only way the legislature is going to maintain control of legislation is if the legislature passes that legislation. If the legislature refuses to do so, the citizens will, and the legislature will not retain control. So while I love the Veterans Clinic, hell, I donate to it every single month, this bill by Basie must be defeated. If the legislator wants control over the outcome of legislation, then they can't be cowards when it's time to act. We are moving into a new election cycle, and there's a push to add full legalization to the fall 2020 ballot. One of the models for the legalization is based upon the medical marijuana model, which would present significant issues and turn larger marijuana companies in Missouri into mini cartels, driving the cost of weed up across the state and restricting the ability of the average person to enter the market and open a small business of their own. To protect against this, the state legislature needs to take action to legalize marijuana before the citizens do it for them by ballot measure. Legalization is going to happen. The question is, who is going to control the outcome? The Missouri State Legislature or the Missouri courts? Now, clearly, the amendment was necessary. We did it because the legislature failed to act. But if the legislature wants to have any control about the outcome of legislation, they absolutely must write the damn legislation and pass it into law. What the legislature has done is they have abandoned their duty to pass legislation that the citizens of Missouri want. After abdicating their responsibilities, they still seek to exercise control over the funds and the outcome of that. If the legislature wants control of the funds, they need to legalize now, they need to do it through legislative action, and then they can fix it. One of the problems we have with the Amendment 14 is that it isn't fixable easily because it must go through a constitutional amendment to make any changes. That's why Representative Basie, in his bill, is seeking to require that there be a constitutional amendment placed on 2020 ballot to amend Amendment 14, because they can't do it without an amendment. While yes, funding the Missouri Veterans Clinic is an admirable goal, the fact that the legislature had to take this extreme type of action to present a bill for a constitutional amendment to make a change is indicative of the problems we have with Amendment 14. As mentioned, the Dormant Commerce Clause issue is one that could break the entire medical marijuana system that we're setting up here in Missouri if that case is pressed and filed. When we come to legalization, we need to approach that differently. Full legalization needs to take place through legislation, through the legislature, so that it can be amended and fixed easily. And if there's a problem, we can address that by replacing the legislatures. Okay, you replace your state rep and your state senator if they're not doing what you want, and then we can address the legislation. That's the way our system was set up to work. New approach in Missouri has started the process of a full legalization, and it's going to happen. The question is, who is going to do it? Will it be our elected officials doing what we tell them to do, or will it be the citizens taking charge because they failed yet again? Okay, please consider these issues. If full legalization is something that you're interested in, you need to contact your state rep. Write them a letter. Do not simply call them. Calls have almost no effect. Write them a letter, send them a fax, give them something that they can hold up in the air and wave on the House floor when they're speaking. The list of reps and senators is available through the Missouri State website. We'll see if we can put something together for you. If you want to send me an email, I will send out an email blast when we know more. And you can always check back and follow the channel. Thank you for watching. Please hit like, subscribe, and hit the alert button so you see our next video. And do me a favor, drop a comment into the comment section. We are considering setting up a Patreon thing. I don't know that much about it yet. I'd like your thoughts. What kinds of things should be offered to Patreons? And I really appreciate it. Thank you. We'll be talking to you soon.